Mr. Chair.
Craig Foss.
Mr. Chair, some issues were raised in the previous part, but actually pursuant to Part 2, Mr. Chair. Just a couple of things. As I noted earlier at the start, this bill rests very, very heavily on the earlier Act, the 2006 Act, in the name of Honourable Marion Hobbs, and where the definitions that the previous member has been talking about were all prescribed, and that member's party, and I think the Parliament, agreed with those definitions as at the time. Mr. Chair, one other point that's been raised is why is this Act, why are we having this now? Will there be another one? Possibly there could be another one, I don't know. But, Mr. Chair, particularly Labor members of FEC will know and may want to share with their colleagues that the liabilities cap was originally 10 billion New Zealand dollars when Westpac was originally incorporated here. It was extended to $15 billion in 2007. Westpac is well within those caps generally, but through the global financial crisis, actually, in 2009, there was an issue, and the asset liability mismatch started to throw that out of whack. Thus, the whole point of this bill is to enhance, to add assets and liabilities to the security of Westpac New Zealand Limited, taking those assets and liabilities from Westpac Corporation New Zealand's institutional bank. Finally, Mr. Chair, a very important point. Again, colleagues, I'm sure on the FEC committee would like to share with their other various colleagues. Questions have been raised about tax and definitions and tax issues. In this part, I refer members to at least Clause 21. For the record, Mr. Chair, I'd like to read that, and that the purpose of sections 22 and 23 in this part is to ensure that the vesting of the designated assets and liabilities in Westpac New Zealand under this Act does not give rise to tax consequences under the Inland Revenue Acts for Westpac Banking Corporation or Westpac New Zealand that would not have arisen if they were the same person. Members also note that we took comfort at FEC from letters of comfort from the Inland Revenue Department as well as the Reserve Bank, etc. And another point to note, Reserve Bank is very satisfied with where this bill is at and these various definitions and clauses, of course. Westpac Corporation obviously is, Westpac New Zealand Limited is, and essentially under tax they will be treated as the same purpose for the same person for the purposes of this bill, Mr. Chair.
The Honourable David Cunliffe.
Chairman, I'm going to get in quickly ahead of my colleague because I want to actually refer back to her previous speech and also to the member who's just resumed his seat. Chairman, this is in a sense the operative part of the bill. This is which provides for the vesting of designated assets and liabilities into Westpac New Zealand from and on behalf of Westpac Banking Corporation. And just to reiterate the very helpful clarification that the Honourable Leanne Dalzell made earlier, that was faithfully represented by the Chairman of the FEC who's just spoken, that it's important to make the public aware that Westpac Banking Corporation means the parent, and the institutional bank assets are part of the parent, and they are, under this bill, able to be vested in or transferred into the ownership of Westpac New Zealand, which is the New Zealand domiciled branch. Now, Chairman, it would be useful from the member in the chair to get a little more background, I think, on record for the public about the circumstances during the global financial crisis in which the cap was breached and that has led to, in part, this bill being required. I may not have been present on all of the days in which this was being considered by the FEC, and I can't recall in great detail that background. I think it would be helpful to the House to get that elucidation from the Chair. I want to compliment the Honourable Leanne Dalzell. I thought her previous contribution absolutely crisply and sharply showed exactly the transfer mechanism that is portrayed in this bill and summarised very succinctly the reasons for it, which we've as a House gone into during this debate. And it's at two levels. It's at the level of the bank itself and the transfer mechanism, and it's at the level of the broader context both of the banking system, the regulators around it, and the broader economic context within which that operates. Chairman, in my brief contribution in the previous part, I noted that the risk factors that were very acute during 2008 and 2009, while they have subsided, have not gone away, and that for reasons of the macroeconomic imbalances around us, and we might add the commodities boom, which dairy farmers, Chairman, in particular, are the current happy beneficiaries of, but being driven by the rapid industrialisation of our East Asian neighbours in particular, who are hungry for the resource inputs to their economies, including protein products, which this country excels at producing. Chairman, that commodity boom carries with it risks that if the imbalances get too great and confidence is lost in the transaction system, credit could again freeze. And I understand from very reliable sources that there have been moments over the last couple of months where there have been signs of real stress in some of those clearance markets. And I think all New Zealanders just need to understand that it's very, very important that we manage carefully for the future. I mean, it's for that reason, Chairman, that the Labour opposition actually supports the government's intention to carefully manage fiscal resources and to reduce debt. And it's the Labour Party's view that we need to reduce debt very considerably over the medium term. We think net debt's a better measure than gross debt. We think we should include Crown financial assets in that measure. But, sir, we are, I think, relatively close on that objective. The difference, and it's an important one, is that for the Labour opposition, debt reduction can never be an end in itself, and it can't be divorced from the other macroeconomic changes which are necessary to support both economic stability and system stability, which is where we intersect again with this bill, and those include building a stronger, more diversified, more innovative, higher value export economy. They include strengthening our savings system and our banking system so that we own our own future. And they include making sure that there's enough, in the jargon of the subject, disposable income, ready's in the pocket, of ordinary Kiwis who are always extraordinary but hard-working families, Chairman,
The Honourable David Cunliffe.
To ensure that the purchasing power is there to keep the country moving forward as well as to feed their families. And that adds up to, I think, 4 interlinked objectives: building the economy, owning our future, helping those Kiwis get ahead, and, of course, the fiscal prudence which must underlie it. And that's how we reduce risk in our domestic economy, and that economic stability needs to underlie the financial system stability, which is part of this bill. Back to this particular part, Chairman, Clause 6 provides for the Governor-General to approve the proposal to vest designated assets. Clauses 2 and 3 allow those assets to be stated either in whole or in part, which may be important because the institutional banking arm of the parent may not wish to vest the whole of a very large set of assets for some practical business reason in the New Zealand branch. The Governor-General may approve amendments to a proposal. That's important so that this becomes a dynamic process, not a static one, and that the vesting of designated assets and liabilities occurs in the way described in the proposal, which is transparent, does not undermine in Clause 9 customers' rights and liabilities, and in Clause 10 does not unduly affect security interests and does not upset contracts, Clauses 12 and 13, and of course, as the member in the chair has noted, has no tax consequences which would differ from those which would have occurred essentially if the bill did not take place. So the bill must be tax neutral I think the committee examined that question and received letters of comfort. We were reassured that there was no hidden agenda here in terms of the tax position of the bank. And that's to be commended. We would note that this bank, along with the other major banks, has recently had some attention to its tax position, particularly in the area of structured finance transaction, which has resulted in them generously refunding to the taxpayer some $2.5 billion of underpaid tax. So we hope that won't recur, because it's important for the reputation of the sector that it does not occur. And I know there's always two sides to the story, but the courts have held that in respect of those cases which went to court, and politicians never interfere in the judicial process once underway, but they held that there was a good case by the IRD and the remaining banks entered into a settlement, and that was appropriate. So it's absolutely appropriate in the light of that, and as a matter of principle, that this House, sir, should be satisfied, should find comfort through the work of the Finance and Expenditure Committee, that there are no improper tax consequences pertaining to this bill, and we are assured and we accept the assurance that there are none. Chairman.
The Honourable Leanne Dalzell.
Chairman, I've just got another question.